गुरुर्ब्रह्मा गुरुर्विष्णू गुरुर्देवो महेश्वरः गुरुः साक्षात् परब्रह्म तस्मै श्री गुरवे नमः. विघ्नेशानमुनी गुरुस स्मरुनी लक्ष्मीस आवाहिले. आम्ही गुंतवणूक शास्त्र शिकण्या हे सत्र आरंभिले. केव्हा स्थावर आणि जंगम कधी कोठे किती गुंतवू. चर्चा मंथन तज्ञ बोध मिळता हे प्रश्नही सोडवू. ठेवी भाग सुवर्ण पोस्ट अथवा रोखे तसे फंडते. वृद्धी भांडवली मिळो कर नको पर्याय हो कोणते. कोठे उत्तम रोखता सुगमता लाभांश वा व्याजही. कोठे गुंतविणे सुरक्षित असे नोंदीस कैसी वही. सन्मार्गे धनसंपदा मिळविणे अत्यंत आवश्यक. पैसा ध्येय नसे म्हणून जपणे जाणीव सामाजिक. ज्ञानाचा उपयोग गुंतवणुकी साठी सदा होऊ दे. हे सारे समजावया सुमती दे आम्हास तू शारदे.
Good morning once again. While the market is taking some breather after a long run from March 2023 to September 2024, we have an opportunity to look at our assets and how we can plan distribution of our assets. And keeping that thing in our mind, we have planned a program along with CA, Mr. Ashok Dhere, estate planning, emotions, rationality and taxation. So there's a very specific purpose behind this kind of topic for being selected today. I will just do a very brief introduction. Though the list of credentials is very long. CA Mr. Ashok Dhere has been a practicing chartered accountant for last 53 years in direct and indirect taxes, audit and management consulting. Has been a president of Bombay Chartered Accountant Society for the year 1996-97. His work with respect to investor protection and education has been commendable. He's been a member of the arbitration panel of Bombay Stock Exchange and National Stock Exchange. He's been a trustee of National Stock Exchange Investor Protection Fund. He's been the trustee of MCX Investor Protection Fund for 4 years. Member of Bombay Stock Exchange Investor Grievances Resolution Panel for umpteen years. And then presently he is with Investor Protection Fund of NCDWX for last 2 years. His work along with Lokmanya Seva Sangh. He's been the honorary consultant for a period of 3 years for Lokmanya Seva Sangh. He's been the member of the managing committee of Lokmanya Seva Sangh Parle for a period of 3 years. He's been the chairman of Anand Dham Shakha of Lokmanya Seva Sangh. He's a member since 1987 of PV Bhagwat Investment Guidance Cell, which we are running here. And he has been the chairman from 2013 to 2020 of PV Bhagwat Investment Guidance Cell. So let us welcome Mr. Ashok Dhere and get
before sir takes over, understanding the nature of topic which is close to everybody's heart, let us keep our mobile switched off so that we remain listening to him uninterrupted. Thank you.
Thank you.
So before sir comes here, we have intentionally taken the first word emotions. Currently all of us are playing with emotions because markets is going down daily. So currently, as Mr. Pradeep also said, keep emotions aside. मार्केटचं काय व्हायचं ते होऊन दे. तुम्ही निदान तुमची जेवढी मालमत्ता आहे तेवढी त्याची तरी काळजी करा आता. म्हणून आम्ही डेरे सरला मुद्दामून रिक्वेस्ट केली. सो ओव्हर टू डेरे सर.
गुड मॉर्निंग एव्हरीबडी. मी मराठीतून पण बोलेन, इंग्रजीतून पण बोलेन. थोडंसं दडपण आलं होतं. आमचे सर आहेत इथे, डॉक्टर वैद्य, ते आज आलेले आहेत. बऱ्याच वर्षांनी ते गुंतवणूक मार्गदर्शन कक्षाच्या कार्यक्रमाला आले. बरं वाटलं. ठीक आहे. I straightway come to the topic because I would not like to spend much of time only just on preliminaries. Uh, in estate planning, I am going to cover only management of estate and passing on the estate and the problems associated with it. I am not going to suggest any ways and means how you can improve your estate, what SIPs, what investment you should make, which is beneficial, and all that. This is only restricted to management and later on inheritance, in which there are plenty of problems which all of us are aware but forget, even though these topics are repeated time and again. The reason for choosing the specific words emotions, rationality, and taxation is that in this tax planning, estate planning, most of the answers would depend upon the emotions of the person concerned and not necessarily based on law, but it is based on many times feelings. That is why whatever you do, whatever you state, emotions are very important in it, that play a role. And as a chartered accountant and as a consultant, I am required to keep my emotions aside and then give an advice. So that becomes a bit of a conflicting role. Rationality, whatever advice you give, it may not necessarily be acceptable to the client. He may not tell you directly, but he has always some reservations here and there, because we try to explain everything based on rationality. And in economics we have learned, and there is a basic assumption that man is a rational animal, and hardly it is true in many cases. So yes, rationality is to be considered, but irrationality is also attached with it, which we shall have to encounter. And taxation, till we are alive, taxation is bound to be there. So wherever there is necessary, we shall give a reference to taxation. अरे बाबा, पुढे कसं करायचंय ध्रुव? तुम्ही slide घेता ना?
त्याचं पेज डाऊन एक सांग सांगू इथे
हा, इथे ना? हा, या, ठीक आहे.
बरं ते टाक.
Yeah. I have mentioned whatever all this given in the slide, which is already given to submitted to all of you. So far as tax planning is concerned, I will not venture to add much, because that's a different topic altogether and it has different dimensions. But then at the back of our mind, we always have some taxation issues. Okay. Then another point which I just wanted to highlight was that this became more important and necessary after 1956. Because after 1956, Hindu law was codified for the first time in 1956. Other laws are not codified as yet. The old law remains. Say for example, Parsi law, Muslim law, or Christian's law. None of these are codified as yet. They remain as they are. But Hindu law alone is codified in the year 1956. And whatever was the uncodified Hindu law, that is no longer in existence so far as Hindus are concerned. So far as others are concerned, yes, their respective laws still prevail. Say for example, Muslim personal law is still the old one, and same Shariat law continues, and we are required to study the same law in our second year LLB exams. 56, and there were few amendments, but one of the major amendment was in 2005, but that's not a separate law. It's a Hindu Succession Amendment Act, where co-parsonage rights were given to a daughter. It was a major change. Until then, those rights were not given. Okay, so we don't call it 2005 law. The provisions in 2005. Yeah. Excluded topics. I have excluded from this discussion, considering the audience over here, business houses. For example, what Mukesh Ambani would be doing. There is no point in any personal taxation or inheritance in his case. What matters to them, because they might be having personal estates for all members of the family, which will be there for generations. What they are interested in is the control over the business. So such topics, such people, their problems are different. They manage it through trust, etc. So those high net worth individuals and business houses I am going to exclude. They follow the route of trust and holding companies. Only one topic which I will touch upon, and that is possibility of inheritance tax. Now friends, in our country there was Estate Duty Act it was established in 1953 and it was abolished in 1983. So far as we are concerned, those who passed before 83, we had to face a compulsory question in final CA examination of 25 marks and most complicated question. Why I am going to touch inheritance law is that there is a strong possibility, because the HNIs and business houses have started managing and planning their affairs from that angle. And in our country also, one day or the other, once again an inheritance tax may be introduced. I know of one union minister with which I was not closely but remotely associated. He has started planning this since 2019. They say because government of any country is always interested in tax collection, and inheritance tax is one of the mode of collection so far as government is concerned. And another thing is, they always say that we follow international norms, and internationally in Europe, America, where we try to follow, inheritance tax is in place. So maybe you have been given a great tax relief in the budget. Maybe next year you might see some sort of an inheritance tax. So inheritance tax is something which may be applicable to us, but then that's something future. I will not waste time, but yes, inheritance tax also needs to be looked into. While preparing for this, I have to consider Hindu Succession Act, Indian Succession Act, Transfer of Property Act, Maintenance and Welfare of Parents and Senior Citizens Act, and the Maharashtra Cooperative Societies Act. Now all these acts, one way or the other, we shall have to touch and deal with it during the course of our discussion. If there is any query relating to that, we shall always tackle it at the appropriate time. And incidentally, my friend Mr. Kale is here. There is no there is no problem in asking questions. Questions are not to be asked to outsiders. I am an insider, and therefore any questions you can ask, even if your views are different than my views. We shall deal with it properly. Don't worry, any questions are welcome. And Maharashtra Cooperative Societies Act. All these acts are available on site. One of the act with which I shall make an immediate reference is Maintenance and Welfare of Parents and Senior Citizens Act. Now this act is passed in the year 2000. What happens is, in our country, politicians rule, and what they thought, that there must have been a hue and cry that you are not doing anything for senior citizens. And so the government at that time passed this particular act. Maybe there may be some trigger, and this act was passed. It was passed in the year 2007. I have called it a this one you can see, it's a toothless tiger. Because the act is passed in 2007, but its utility, usefulness, and problems are still remaining. And that's why I just spent some minutes on this. Why I call it a toothless tiger is that so far as this act is concerned, it is passed by the central government, but its entire implementation is left to the state government. That is one reason. The second is, so far as state government is concerned, many of the provisions of the act say that state government may do this. I mean, there is no compulsion even on state government to do this. For example, there is one provision that state government should establish old age houses for senior citizens and parents. No state government has done it so far. But then yes, there is an act in place. If the state government is willing and ready, they can do it. But nobody has time for that, and that's why I call it toothless tiger. Thirdly, earlier in uncodified Hindu law, maintenance of parents was considered to be a pious obligation of children. That was religious as well as it was pious. After 1956, it has no longer remained a pious obligation at all. And therefore, even after 2007 Act, the pious obligation is tried to be restored to some extent, and that is only in respect of children are concerned. That is, children are supposed to take care. Relatives are also supposed to take care of children and senior citizens as per this act. But then the relatives are supposed to take care, other than children, only if they are likely to inherit any property from that senior citizen. And assume for a moment that senior citizen doesn't have property, doesn't have means to maintain himself, then in that case there is no obligation on relative. There is no obligation on children also in that sense of the term. Yes, there is only a pious obligation which has been restored. To the extent what they do is anybody's guess. That's why I call it a toothless tiger. It was just introduced in the act for the sake of some consumption, public criticism. You must do something for senior citizens. There is always some hue and cry, and then this thing is done. And you will see the reference to that in this first slide itself. Now I am going to tell you a story of a helpless father. Now this is a case of 1968. There was one person who used to come to teach me yoga when I was a student, and I had some good intentions to learn yoga. So he used to come. He was staying with his son, daughter-in-law, and a small child in a chawl in Girgaon earlier. His son was working in bank, he decided that in Chal area he has to sleep in the kitchen. His mother was not there, so why not shift in suburb? So he bought a spacious flat with bank loan, etc. at Andheri, 2 bedroom flat, one flat for himself. I mean that son, one flat for father, spacious hall, things like that. And for this, his father sold his Girgaon 2 houses. When these 2 houses were sold, the money was a pagdi money, it was a black money, and that was necessary for purchasing that flat. So that money was spent on that. It is all unofficial. And some furnishing. Gave him some provident fund money also without anything in writing. The son took a loan from bank because he was a bank employee. His daughter-in-law also took some loan from, and her name was also put on the flat. Flat was purchased. They were very happy that from old place like Girgaon they came to Andheri, spacious flat, and it was a luxury like a bungalow for them when they came here. Things were going on well, all right. 6 months while catching a train, he lost control over the bar and he fell down, and that son died who was working in Bank of India. Now, after his death, there were issues. No problem, nothing happened. In about a year's time, his daughter-in-law, who is, we can call it Samadukhi, met a Samadukhi person, another person of her age with similar problems, and she decided to marry him after 1 year. Now look at the plight of this father. Now his name is not there in the flat at all. The son died. So it's a case of Hindu male dying intestate. Hindu male dying intestate, property goes to children, widow and mother. There is no father. Father is in class 2 here. So if there is no class 1 here, then only class 2 here comes into picture. Here was a case where child was there. Here was a case where their widow was there. So child got 25%, the widow got 25%. In other words, the widow became 75% owner of the flat without any difficulty, and 25% also as an owner because she was a guardian for that minor child of 2 years. So she was 100% owner of the flat. Now this lady, obviously she was young, she wanted to marry. The person with whom she wanted to marry, he had no place to live. So he came and started staying at this place. Now here is our helpless father. He is staying with his erstwhile daughter-in-law with an unknown person, and that is happening only because he does not happen to be a heir so far as class 1 is concerned. That's number 1. So that's a care which one has to take while giving estate to your children, either during lifetime or after death. Another mistake he made was he should have insisted his name to be put on the flat as one of the owner, because although there was no official record, he had contributed 45% of the purchase price, including pagdi money and provident fund money and all that. But provident fund money, there was no loan agreement or nothing of that sort. So that was treated as a gift. So he has no money. Some fund money was left. No old age home. and he was finding it extremely uncomfortable to live at that place where in reality he was 45% owner, legally he was a stranger. That's why I said this Maintenance of Children and Parents and Senior Citizens Act doesn't apply over here because he doesn't have children. His only child died. So children, there is no question of maintenance. No old Hindu law helps him. So other relatives are also not coming forth. So that is to some extent the lacuna in Hindu Succession Act, which we can't change. There is also appears to be some problem in Maintenance of Parents and Children Senior Citizens Act. That also we can't change. So all that we can do is we can advise all senior citizens, Babare, you can give to anything to your children, only that which remains with you after you are taken care of. Just as when we are in an airlines, there you are supposed to take care, put on jackets first and then save the child which is next to you. Here also, here you are supposed to take care of you first and then you can think of giving anything to your children. It doesn't mean that you need not give anything to your children during your lifetime. You can. The only thing is keep yourself everything. Supposing if you were to insist that my contribution to this flat is 45% in the estate, my name should also be there on the flat purchase agreement. If that agreement, his name was there, then his daughter-in-law, erstwhile daughter-in-law, could have been compelled to give him 45% of the market price of the flat at that time. With that money, he could have stayed somewhere else. At least he would have got his money back. These are the things which we do not encounter, which we do not take care of, and that is why we are in problem. Because I came across this case, I told you I do not know what happened to him later on, because later on he stopped coming, and I also lost interest in yoga. So that's the thing which you have to take care. Yes, that's the thing. Tangible property, intangible property, and 2007 Act does not help. That's the lesson that we learn. You can always say that the erstwhile daughter-in-law should have taken care of him, should have given him money. But these things are only said by way of good wishes. Does not happen in real practice. Things are very different. Now, plight of a young widow. Now I am going to take 3 cases where one is a case of no insurance, second is a case of underinsurance, and third is a case of suspected overinsurance. And in all these 3 cases, how your estate suffers, your property suffers, and you are in some sort of a problem. Now here, it's a case of Pune person. He was working in Telco as a engineer, fresh engineer. Telco is now known as Tata Motors. His wife and 1 child. Wife was not employed. Child was just a couple of months old. I had been to Kolhapur with one of my clients who happens to be close relative of this person. When we were in Kolhapur discussing all those matters, we got a telephone message saying that near Karad, so-and-so's motor car met with an accident and he died on the spot. The body is in Karad hospital and you are required to go there immediately and take body and come back. So we stopped our discussion what was going on in Kolhapur and we rushed to Karad. We took everything, all those formalities took time up to 2 o'clock. Since morning we had not taken breakfast. Our lunch time was over. The body carrying that this one was in front of us. We were all hungry, carrying a dead body. So somehow or the other, we just took our car in front and said, let's wait for some tea, coffee. Because it was difficult to tell him that we have to take lunch or something, eat something. Tea or coffee, we said. And then understood and things like that. But then that becomes a problem. A person is dead, we are living, and we have our daily routines. So that cannot be forgotten. Just by way of an interest, there is a book called Ram Nagari. It is written by Ram Nagarkar, who was a famous actor in Vichha Maji Puri Kara, along with Dada Konke. He had written this incident. Ram Nagarkar was on set, and he got a telephone call that his mother is dead and he is supposed to rush to his house. So he immediately got the train, came to Veti station. That time he was staying in a chal in Bora Bazar, just 5 minutes away. What he has written is, first he went to some nondescript hotel, ate lot of misal pav and things like that which were available at that time, and then went home. Because in their community there is a process that when the person who is to carry the last rites, he comes, he is supposed to hug every other relative and cry as loudly as possible, so that there is some solace to that person who died. So he knew all the process, and he said that by the time he gets some food, it will be 7 o'clock because he will have to go to crematorium and come back. So he has written. So first he ate and then he went and did everything. Well, friends, this was a case of that telco engineer where he had taken the place in Kothrud area, working in telco, and that time Kothrud area was just outside, they considered outside Pune, and the loan was taken from newly started HDFC, and there was no mortgage insurance policy. That time housing finance companies or the banks which are giving housing finance, they are not considering mortgage insurance policy is a must. Even LIC has got this mortgage insurance policy. Nobody knows about it because agent doesn't get any commission, worthwhile commission on that policy. Later on, HDFC and other housing finance companies started insisting of taking mortgage insurance policy as a part and parcel of their requirement of disbursal of loan and things. But then that was the beginning of HDFC also. HDFC had not insisted. He had not taken loan. His wife, widow, had to sell off that flat and go back to Sadashiv Plate Road residence. And look at her plight. She was treated as Pandra Payachi by her in-laws, and she was not welcome in father's house because they had no money and nothing to support her. All this happened because of absence of insurance. We are always told that in investment you must look at safety, liquidity and profitability. Okay. So far as immobile property is concerned, safety is in insurance. That should have been taken, that should have been insisted upon, and that was not done. That was the plight of no insurance. And supposing she had taken that policy, then what would have happened? That all that HDFC loan would have been paid by the insurer. There was no obligation to make repayment. Then she would have got that flat free of any encumbrances. She would have been the owner of that flat. She would have some property of her own, and she would not have been a victim of in-laws or the bad situation of her parents. So that was the case of young widow, no insurance. Yes, this is a case, no insurance, property mortgage policy that I told you. The next is a case of all eggs in one basket. Here is a case which happened just 4 months ago. This person concerned was running a small factory in Bangalore, and in that factory he was doing very well. He was nearing a senior citizenship. He and his wife, daughter abroad, and he was doing well in the factory, but he has no other investment. He was not having any mutual fund, shares, bank fixed deposit, everything in the bank. And the property, that is plant and machinery, and the stock, that was some 15 crores. And he had taken a nominal overdraft facility of 1 crore. That was also he had never used, because he was never required to utilize that overdraft facility. Because the overdraft of 1 crore, bank was happy with an insurance of 2 crores. No, insurance of 2 crores was taken. 4 months back, that factory gutted in fire because of short circuit, and the entire stock and the entire machinery wiped out. So all his wealth of some 15 crores, not a small sum, only wiped out. He will get, probably after the claim is submitted and all that, some 2 crores rupees from insurance company. Now here was a case of underinsurance. If your stock was 15 crores and if that is your only asset, stock and machinery, if that is your only asset, then in that case you should have taken insurance of 15 crores. Doesn't matter, even if you have to pay a higher premium, you should not restrict your insurance policy to the amount of overdraft which you have taken, which you never use. You don't require it. So from a 15 crores net worth person, he has now become just would be 2 crores person, because that insurance claim is yet to be settled. Because the insurance company is always suspecting something when the big claims are there. The third, so here the mistake was all eggs in one basket. That's number one. And number two, to save some insurance premium, he had not insured his property properly. So that should not, that is a taking care of your investment. Business assets, personal insurance, under insurance. So that we have covered. Now, before I come to deeply hurt father, I would like to tell you a story of over insurance where I was myself involved. And it was a case of one of my clients, private limited company. And in that private limited company, husband and wife director, their factory at somewhere down the line beyond Virar. He had taken a big insurance policy, some 50 crores. And one fine morning in 2016 July, the fire broke out and his entire factory was burnt. There was an insurance claim of 50 crores. Okay. So probably he thought that, and he had taken bank loan. So there was a bank loan against stock and machinery, and there was an insurance also. Insurance company suspected that this stock is over-insured and this fire is something which is not natural. You have done something So that was a suspicion of an insurance company. Because the insurance company was not making payment of the claim, the bank loan was not repaid, the bank loan became an NPA as per those rules, and bank filed case against him. There is a direction that if your loan amount is more than 5 crores, then in that case you have to file case immediately. You have also to inform CBI because that's the rule. Insurance company was reluctant to pay such a big amount. They were trying to find out what lapses are there. And in that case, the cases were going on from 16 to 24. In the month of 24 August, I got a call. I mean, not call, email. In such and such case, you are required to come and give evidence. Because I was the auditor, I had certified the stock, and this is the stock which is destroyed by fire. So I was called. I went there to CBI office, and first the CBI officer, inspector level person, he always treats you as if you are a culprit. That is the way they behave with you. They are always culprit. Here, I am an abettor because I have certified the stock, so I am an abettor. So all sorts of rough questions were asked. To be very frank, I was also afraid. Although I have not done anything wrong, I had certified stock with all qualifications that I have not received purchase bills, I have not seen sales bills, I have not verified the stock, I have worked out the value of clothing stock based on fire claims problems that we teach in classroom, taking the average gross profit of earlier years and work out the stock. So that stock is a derived figure. All these things detailed note I had written in the audit report. Still, they are not satisfied. You must be an abettor of this person. So all this questioning going on for a year or so, 3-4 hours. Go for lunch. There is a canteen on 10th floor. You can have something. We shall meet after lunch. No courtesy to offer even a cup of tea after 4 hours. That's CBI. So I said, I don't want to go for lunch. You come quickly. I would like to finish. After lunch, they came, and afterwards he became a bit friendly. There was one document which he wanted. Call for that document from your office. Ask them to send it immediately on mail. Within 10 minutes, that document should come. I said, all right. But I don't have phone. You don't have phone? No, sir, I have phone, but you have taken it because you don't allow persons to come in your cabin with telephone, cell phone. So he gave me cell phone. I got the papers, gave him. At the end, he became a bit friendly. And he asked me, sir, how old are you? For the last time he called me sir. Sir, how old are you? Earlier, he was looking at me like a culprit. So, how old are you? I said, I'm 79. The case will come up for hearing after 10 years. Will you be in practice at that time? I said, I don't know whether I will be there tomorrow. So, what 10 years? The truth of the matter is, the CBI, the banks are compulsorily asked to file CBI cases wherever the loan amount is 5 crores rupees and more. So bank has filed the case. Insurance companies, wherever the claim is put, they have to take the help of CBI to find out whether there is anything illegal. And wherever the claim amount is more, they always try. And so here the matter was going in High Court, arbitration, Supreme Court, again back and forth. So neither insurance company was willing to pay, nor the bank was willing to pay. And under compulsions, they were filing cases against persons which may come up after 10 years to take evidence from persons like us. Well, that was a case of over insurance. because they suspected that there is over insurance. Just to take money from insurance company, this policy is taken, etc. Yeah. Now here is a case of deeply hurt father. Now the story goes back 25 years back. He happens to be my client. He had two daughters. One was aged 23, passed MCom. Another was studying in college. Now this daughter, 23, passed MCom. Somehow or the other she fell in love with a waiter who was working in a hotel, the type of Jivan or Ramakrishna as we have. Because hotels have also grades. 5-star waiter is different than greenhouse waiter. Greenhouse waiter is different than Ramakrishna waiter, etc. etc. So he was a waiter in such a hotel. Now, why she married such a person, I don't know. His father doesn't. Her father doesn't. But married. And then father, mother, everyone, तू आम्हाला मेलीस, आम्ही तुला मेलो. माझ्या प्रॉपर्टीमध्ये तुझा काही हक्क नाही, तुझे आणि आमच्या याच्या पुढे काही संबंध नाही. ठीक. Sometimes these things are said in a anger, bit of an anger. I am sure her mother, maybe after her child was born, etc., must have spoken to her. But in front of her husband, she also keeps that short. We don't see her face also, anything of that sort. So she had two children. What she was doing, we don't know. Now the story comes 25 years back. His other daughter was well educated. She became a chartered accountant and looking after his parents well. And the question of age, so he wanted to give his property, so made a will, and he came to me. I have prepared a will and I have excluded my elder daughter from the will. I have not given her a single farthing, and it is like that, because I have not yet excused her. She has married against my wishes. आमच्या कुटुंबाचं तिने खूप नुकसान केलं, अमुक तमुक वगैरे वगैरे बऱ्याच गोष्टी झाल्या. म्हणलं तू विल केलंयस, ठीक आहे. मग विल केलं, मग काय त्याचं पुढे काय तिला काही मिळालं नाही पाहिजे. त्याची प्रॉपर्टी समथिंग लाईक 10 to 15 crores आहे. त्याच्यातली इमूव्हेबल प्रॉपर्टी 5-6 कोटीची, बाकीची आहे ती मुव्हेबल प्रॉपर्टी आहे. सगळीच्या सगळी मी माझ्या धाकट्या मुलीला दिलेली आहे, मोठ्या मुलीला काही दिलेलं नाहीये. आणि विल मध्ये तर स्पष्ट म्हटलेलं आहे की हिने माझ्या इच्छेविरुद्ध लग्न केलं वगैरे वगैरे. ठीक आहे म्हटलं, मग तू केलंस विल वगैरे. मग म्हटलं मला जर त्या मुलीनी तिचा ऍडव्होकेट म्हणून अपॉइंट केलं तर मी हे बिल चॅलेंज करेन. कसं हे बिल चॅलेंज करणार तू? तर इट इज ड्राफ्टेड बाय सिनियर ऍडव्होकेट ऑफ हायकोर्ट. He has taken consultation of some solicitors, and how can you challenge that will? This is foolproof. I said, I don't say it is full. It may be foolproof also. You might have registered also, but I'll still challenge. I'll challenge it on the ground that there is undue influence. I will challenge it on the ground that the immovable property is not purchased by my father, so he had no right to make a will of that property. The property which is ancestral property, cannot willed away. You can will only your share. Now there are 8 Supreme Court decisions on conflicting. I will not bother you. But there is a big problem about the ancestral property, whom to go and where to go. So I will take that stand. I will say that this is ancestral property, and so he had no right to make that will. The will was made under undue influence. There was compulsion, there was coercion. I was excluded unnecessarily. My mother was in my favor, had contacts with her. I will raise thousands of objections and I will challenge the will that Maybe I will succeed, maybe I will not, but I will fight it. And the will is something, first of all, we, all of us should give up an idea that whatever we write is something sacrosanct which nobody will ever challenge. Your will, whatever you have done, can always be challenged. It is to be proved in the court of law that it is correct. Once it is certified, then it becomes a valuable paper. Till it is certified by the court by way of a probate, that will is a waste paper basket. You can just throw it in a waste paper basket. It has got no other use at all. This Bal Thakre's will, it was challenged. It was challenged, although it was drafted by topmost solicitors. It was witnessed by the lawyers, the doctors from Lilavati Hospital, and yet this will was challenged. Thereafter, we don't know what happened because parties to the dispute, they agreed for in-camera hearing. So whatever is the outcome, that is not known to us. But the will was challenged. Will can always be challenged. I'll give you another instance where Lokmanya Seva Sangha was involved. Just behind Lokmanya Seva Sangha building, there was a lady. She was alone. She was staying in her own flat. Her husband was dead. She had no children. And she had decided that she will give her entire property to charity. And Lokmanya Seva Sangha was also one of the beneficiaries because that function was held in this Sathe Sabhagara itself. She had given to different charities, different mandirs and all that. She had chosen her next door neighbor, 40-year-old gentleman, to be the executor of the will. This will was also challenged. Challenged by whom? She had no husband, no children. So challenged by those persons who under Hindu law as well as under uncodified law are known as agnates and cognates. Agnates means the persons who are related through paternal things, and cognate means the persons who are related through maternal. So agnates and cognates were there. So they said that this will is bogus will, we should get the share of property, etc., etc. That 40-year-old young man was very enthusiastic. He said that I will fulfill her wishes. He fought all those cases for 10 to 12 years because there were several cases. And ultimately, he got the probate of will, sold the property, and distributed the proceeds as per her wishes. So the point that I am trying to drive at is, you have drafted a will doesn't mean that it is the last word. Forget the ego that your word is final. Somebody else can always challenge that word, whatever you have written, and the will is always subject to a challenge. Only thing is, it has to be proved in the court. Okay. So property rights, I will challenge. I told you how I can challenge that. Whether I succeed or not is a different issue, but I can challenge. The conditional gift and validity. Now this is something, I would like to state that here in this hall itself, there was a lecture, and in that lecture it was stated that conditional will is not a valid will, etc., etc. And I was not present, and even if I were present, I would not have taken a stand contrary to him, because that's a ethics which Limay sir has taught us. We don't. But I said, you can challenge me or ask me cross questions, because I am not an outsider. I belong to this PV Bhagwat Investment Guidance Cell. So you can always challenge. So here was a case where he had stated that if a gift is given with the condition that the person concerned will maintain the person giving the gift till his life and take care of him, then if such a gift is valid or not. That was the question. Now here also, I don't blame that person who came here to give the talk. Our Supreme Court, nobody is the reporter over here, is also funny. Supreme Court word is final. So in 97 there was a judgment. I will not bother you with the citation of the judgment. 97 there was a judgment that a conditional will is not valid. In 2003 there was another Supreme Court judgment which said that conditional will is valid. The first judgment was not cited before the second judgment. And then in 2007, when this Maintenance of Parents and Senior Citizen Act was passed, the third judgment came, and it was a larger bench which considered that issue. And in 2007, they said that conditional will is valid, and you can put a condition that person, say father giving a gift to a son, then son and puts a condition in the will that son will maintain him till he is alive, fully take care of him. He will maintain his mother till she is alive. So both of them are taken care of till they are alive. And such condition can be imposed in a will, and that in the gift deed is valid. That was 2007. Again the matter came for consideration, and the latest judgment is 2nd January 25. And 2nd January 25, Supreme Court considered all the judgments. I have kept that judgment. I have given it to Dhruva. In case those of you are interested, can get a copy of that judgment. Urmila Dikshit versus her son. Son's name I have forgotten. That is the case. Now, the son is directed to give back the property to his mother on or before 28/2/25. That was the direction in the court. So the point that I am trying to drive at is conditional gift is valid as per the latest Supreme Court judgments. So therefore, I have always advocated to whosoever asks me that if you have any immobile property like flat or plot or anything, then in that case, why don't you gift it to your son or daughter, whomsoever you want to do it, during your lifetime itself? At least in Maharashtra, there won't be any stamp duty on this gift. No stamp duty. At the same time, the cost will be less. After death, you will have to face the cooperative society, you will have to face other officers, you will have to go to high court, you will have to execute sometimes release deeds, and you will have to spend minimum 5 to 6 lakhs rupees. Time will also be there. Running around will also be there. Consider the cases of persons who are abroad. So they don't have time to come here and fight out all those court cases. They may not have a person of their confidence who can do all those things in their absence. So why do that? Give the property to them during your lifetime as a gift completely, and put a condition that yourself or your wife or whatever the case may be, they have a right of stay in that particular property till they are alive. That life interest is preserved. And if that life interest is preserved, there is no harm, and all this cost and expenses, etc., can always be avoided. And that's why 2025 judgment, I have kept it on record. Those who want it, Dhruva will be able to send it to them. So conditional validity. that I mentioned, Urmila Dikshit versus Sunil Sharan Dikshit. Sunil Sharan Dikshit happens to be her son, and the son doesn't want to maintain his mother. So these are life. This is life, reality. That's why the topic, reality. So reality, son doesn't want to maintain. Son wants the gift which is given and doesn't want to maintain. So the Supreme Court has come to her rescue and directed that property. So she can, once she gets back the property, if the son doesn't maintain, she will sell the property and maintain herself. And the son will then keep quiet about it. He can't do anything. Okay. Then I come to mystery of nomination. And here also I will talk about the Supreme Court case. And typical case where state is concerned, how the children behave, how the parents behave, and how nomination plays a part in it, and how nomination alone is not sufficient. All this is highlighted by the Supreme Court decision of 2016, and that is the case of Indrani Vahi. Now this Indrani Vahi case, I had, you just tell me 5 minutes back, huh? Because when I start talking. So Indrani Vahi, it's a case, it's a typical case. That judgment came in 2016. It's a case of husband, wife, son, daughter-in-law staying together. He has one daughter who is married, stays in a different city. But who is at fault? That is not known from the judgment. This husband was not having good relations with his wife, was not having good relations with his son, he was not having good relationship with his daughter-in-law, and they were always fighting. So one fine morning, he collected all his belongings and he went to his daughter's place and stayed there. When he went to his daughter's place, daughter and son-in-law welcomed him. He stayed there for 2 years. He was in the meantime not well and hospitalized. All that was taken care of by his daughter. He had made the nomination of his flat where his son and daughter-in-law and his wife were staying in favor of his daughter. And he had told her that this flat is yours, you take it, they are useless, they don't take care of me, and all sorts of things. Abuses also to some extent, because it's a case from Calcutta. So they have that tendency of using abuses. So I don't know what. And the hatred between them was so much that after staying for 2 years with his daughter, he died at his daughter's place. His wife as well as son did not come even for the last rites. And daughter claimed the property. And the Supreme Court judgment, after to and fro, there were various judgments which I am not bothering you, but it is there in full text of the judgment. Supreme Court held the flat should be transferred in the name of nominee. Nominee is the absolute owner. Cooperative society is directed to, I have even marked in yellow all those linings. And that time, WhatsApp University spread that matter like anything. Cooperative society is prevented from objecting to a nomination. They are bound to transfer the flat in the name of a nominee. Nominee is the absolute owner, says Supreme Court. And all these extracts from Supreme Court were also given. All these extracts were given, and and the objection was what? Daughter is not a valid nominee. That was the objection taken by the son. On the ground that West Bengal Cooperative Societies Act requires you to make a nomination in favor of only family members. And he contended that daughter is not a family member because she is married into another family. Then, so whether in Maharashtra, under Maharashtra Cooperative Societies Act, nominee can be any person, need not be a member of the family, can be any third person also. So, court held that married daughter is also a member of the family. So the nomination made in her favor is valid, and all those wrong nominations, and the WhatsApp University spread that message like anything. Then I came, what everybody forgot, and I will read it completely, those 4 lines. After talking of all those things, the cooperative society has no option whatsoever except to transfer the membership in the name of a nominee, that is the daughter in this case, in Ranivai. Like that, 3 or 4 other places also this has been stated. What everybody forgot, because one is very tempted that something is in their favor, just run. At the last, in the last 4 lines, the Supreme Court has stated, it shall, however, be open to other members of the family, personally son and daughter, to pursue his case of succession or inheritance if he is so advised in consonance with the law. Now, this is nowhere mentioned. And that is the principle of nomination, is that nominee is only a trustee. He is a temporary owner. He has to hand over the property to the legal heirs as per the succession certificate or as per the probate of will. Until that time, he can hold the property, not permanently. That's the law. And that is not only applicable to immovable property, but it is also applicable to movable property also. And that creates complications which are innumerable. Now, that was that Indrani Vai's case. It's very interesting judgment how we spread and how we fight out, and how here father made one mistake. If he was so obsessed with his son, etc., then in that case he should have made a will, and his daughter should have obtained the probate of will. The entire flat would have been her flat as per her father's wishes. Her father's wishes here could not be fulfilled because he did not put he only made the nomination. He thought that nomination is sufficient and he completed the process. That's not enough. Nominee is only a trustee, a temporary owner. This fact should be kept in mind. Indrani Vai, I told you, WhatsApp propaganda. In Maharashtra, everybody knows now that either you have to nominee is only a temporary member, and you have to obtain either succession certificate or probate of will or release deed, etc. You have to complete. Before that, the property is not transferred. Fine. This is not in the act. This is not in the rules. This is in the model bylaws, and that too by way of a footnote. Tomorrow there could be a crack person. That model bylaw cannot be the act, and this provision is therefore redundant, should not be, etc., etc. Whether somebody will succeed or not, I don't know. But this is only an amendment in the bylaws, model bylaws by way of a footnote. No amendment in the act, no amendment in the rule. And maybe some lawyers will take up the issue if they so desire. Well, rush back further. Now, before I come to the nomination of movable property, let me try to complete this, because if the time doesn't permit, I will come to that slide. Guardianship is an asset. After 4 slides, I skipped 4 slides are related to movable property, and that I will take up only if there is time. Now, here is a case. We all talk about will whenever there is a lecture of organized by Lok Satta for will, etc. There is a full Pula Deshpande hall, full Korili Yugo, the halls are full. Everybody is interested in knowing what the will is. Very simple. All that you have to do is you have to write your will in your own handwriting. You have to appoint an executor who will execute the will. You have to write who are the beneficiaries of your property, and you have to sign it in presence of 2 witnesses. That's all. So although I might have told you earlier, guardianship is an asset that I will take up, and it's a case of planned suicide and how here the will helped. Now here was a case where there was a husband, wife, 2 small children, minor children, and mother-in-law. Mother-in-law and daughter-in-law always fought. There was always tu main. And Sunday they fought vigorously, because Sunday son and the husband of the other used to be in the house. He was watching match on TV, and both mother came once, see what your wife is doing. Then wife came, see what your mother is doing. He got fed up. You fight, whatever you want to do, you do it. I am going to Shirdi. So he took his car, straightway went to Shirdi. He was driving at a speed more than normal. Near Kasaraghat, he met with an accident. He was in Jaslok hospital for 12 days. He died. Then all those blame game and rituals and everything took place. And after 4 months, his wife started looking, sitting in the shop. They had a shop. They were very rich people sitting in a shop. She was running the shop. And one fine morning, she took out a stationery from the shop and wrote in it, "My husband died in such and such circumstances. I find no interest in life left. I have only 2 children. I appoint my father as the guardian of their person and property for the rest of this one. The will was, I give all my movable and immovable property to my 2 children who are 11 years and 9 years old equally." So look at here. She had not used any stamp paper, green paper, or plain paper. It was written on a stationery in a shop. She had not even described what the property is. She had stated, "Whatever is the movable and immovable property in my name, that everything I give it to my 2 children. One half to X, one half to Y." So she had not even described the property in detail. Whatever is my legally owned, I give it. She had appointed an executor. She had said that my father will be the executor of this will, and he will take care of my children and their property. So she had appointed an executor. She had also appointed a guardian, because under Hindu Minority and Guardianship Act, normally their paternal grandmother would have been the natural guardian in the absence of father and mother. But here, maternal grandfather was made the guardian, and she took the signature of trusted servant from the shop. Signature was taken. She closed that envelope, posted it, and her father in Delhi got the news that she has jumped from so and so floor and died. And she also, that letter also reached. It was very tragic and things were very sad and all that. But it gives the essence of the will. The contents of the will were not known to even the witnesses who signed the will in her presence, because witnesses need not know. They are only to say that this person has signed in my presence, that's all. If they were to know, then they know they were faithful servants for many years, they would have immediately informed all those persons. They did not know what the contents are. So contents of the will need not be disclosed. Incidentally, 4 or 5 days back, there was a newspaper report that father-in-law, grandfather was killed by grandson, because in the will he was given only 4 crores property and other grandson was given some 6 crores of other property. So, but then the poor father, that grandfather, old man, why should he disclose to his grandsons what he has given? But we will take pride in declaring, I have given you X, I have given you Y, I have given you Z, I have given. Why? You mention it, keep it quiet and let them have it after you are dead. Why bother about it in the beginning? But then, no, this was the case. She committed suicide. And this matter went to Mumbai High Court. This was my client's case, so I knew it thoroughly well. And in the court, High Court, it was not the will that was challenged, it was the guardianship that was challenged. But the High Court held that guardianship be given according to the will. The will is valid because it has all the essential conditions that are required in the will, and therefore this has to be done, and accordingly that was done. So that is a planned suicide. And then after telling these things several times, one of my own client, I will not name, he asked me to change the will 2 times, 3 times, 4 times. He changed it. Ultimately, everything was fine. You say, but sir, it has to be on a green paper, no? Why you are not use green paper? Send me a fresh copy on green paper. I changed it, bought green paper, and sent it to him. So all these. I have done registration. Madhya Pradesh High Court has just, I think, 8 days back given a verdict that registration of a will is not something which is sacrosanct, and if you have registered the will, it has got no effect unless you obtain probate of will. Till that time, it's a waste paper. So, will is an official document only if it is certified to be the true will of the late person by the competent authority. High Court in 4 states, 4 presidencies like Bombay, Madras, Delhi, Calcutta, and district court in other places, in other court district places. So guardianship, I think 12-20 time कुठला आहे? Contest of a will is a perpetual threat. I told you. Bal Thackeray will, yeah, no relatives. Before generation Z, I will come to other movable property nominations and SEBI directions and RBI directions. Yeah. Recently, that is December 24, Parliament has passed an act, uh, Banking Laws Amendment Act, and as a result of which the nomination can be for 2, 3, 4 persons. Nomination can be serial or nomination can be sequential. All that they have stated. Nice wordings, how they get it. And also, Reserve Bank of India has issued directions. This does not become this 19 December 24 Act, which is introduced, passed by Parliament, does not become an act until it is passed by Rajya Sabha and later on it gets the President's assent. Well, that will take course, in due course of time it will happen. But the problem is our emotions and our writing and our nominations and our rules and regulations. For example, I have come across number of cases of my own clients. You will also come. I have bought a flat. It is in my name. I have paid for the flat entirely. But on sentimental grounds, I have included the name of my wife as well. For income tax purposes, I am showing this flat as my own flat. Everywhere, when in the event of death, she is treated as 50% owner. And that matter is forgotten. In one case, husband had bought property. He had 3 properties. He had bought all 3 properties in joint name, his name and his wife's name. Unfortunately, his wife died 6 years back. And then for everywhere, the sub-registrar said that she is 50% owner and her sons, her daughters will get share of that property, and you can't make a will until this issue is settled down. So we always, I have faced cases in income tax also where property is purchased by husband, but wife's name is also mentioned therein. We have to prove that all the payments are made by husband and technically the property is in his name. However, for sentiment's sake, it is kept in the joint name. Registrar, sub-registrars, they don't accept it, stamp duty and all complications that follow. Innumerable complications are arising out as a result of this. The same thing happens in joint bank accounts. Now, we always have that presumption that if I have a bank account, my wife's name is second name. For income tax purposes, all transactions in that account like sales, purchase, expenses, I show in my tax return. My wife's name is there for the sake of sentiments, for the sake of convenience, and in the event of death, she can immediately operate the account because it's a joint account. The same thing goes where her name is first, and that's the case with most of us. We do it. Will that be true insofar as nomination is concerned? The answer is what the bank will do. I have yet to get the answers. Bank will make the payment to. Bank will transfer the account to the second person because it is either or survivor. Payments will be made. Yeah, you can say.
Only if there is an intimation given in writing by any of the survivors saying that this person is liable to pay. Otherwise, in a today's environment, online transfers are and anything. So if you just only bank, you only start acting only after that to the information. Or alternatively, one of the successful the police or to the court and get a order to ask bank to stop. Otherwise, the bank manager will not know. The clearing may check the person. then nothing you can do.
I-
That's my stand.
I 100% agree with you. In fact, the nomination in movable property, where the nominee must get the property immediately, but he takes it as a trustee, neither the DP nor the bank nor these persons are responsible. They have, once they have completed their obligation so far as nomination is concerned. It is for the heirs to fight between them so far as that property is concerned. That is, according to us, the settled law. But that settled law appears to be disturbed because of various SEBI directions which have recently come, as well as RBI directions which are coming, and they cause confusion because banks do not know. And therefore, all that I can say at this stage, only when 3 minutes are left, that you take care. Better ask persons like Sujit or someone to Dhruva to take care of it, because this is a problematic area. What will happen, you and I don't know. The best course is transfer all immobile property during your lifetime, keeping your life interest in that property, and transfer even movable property to the extent without transferring income or the assets. Okay? I am grateful to you for Harishchandra is no more a king. Yes, in 1 minute I will tell you. This is the case where again a father had said that I have 4 properties. I give 3 properties to my son, 1 property I give it to my daughter, but there was no will made. Father died, mother and son was there. Son prevailed on his mother, whereby mother transferred even that 4th property in his name by way of a gift, and married daughter, came to know about it only when she knew after the death of her mother that the property has already been taken away by her brother. It's a case of Harishchandra is no more a king of India. Brothers, whatever your father has stated, neither the son nor the daughter at times will view that one. You have to be cautious. There may be some other issues which I would have. Anyway, we must finish it in time. Thank you very much for your grateful hearing.
Thank you, sir. Thank you very much. Sir, by the way, was my professor in Danukar College. So, sir, thank you very much. For questions, you can always go to Dhere sir's office. He's in Vile Parle. आणि ते नक्की चहा देतील तुम्हाला. But definitely, I will not entertain your people to ask questions here, because this is a very sensitive topic. People might have some reservations in asking questions openly amongst all of us. So, and they are never ending actually. एखादं जर सुरू झालं, सून अशी करते आणि सासू अशी करते, तर मग तिथे आम्हाला जेवण वगैरे अरेंज करायला लागेल रात्री. तर I would request people, if you have any questions, you can please contact Dhere sir. Sir, तुमचा नंबर असेल तर ते किंवा Dhruv or I will share Dhere sir's contacts. So thank you very much, sir. Thank you for enlightening us.